Michael Jaafar, sorry about that, Michael. It's good to see you. I want to ask you about how this must be coming across to the jury. We're getting a lot of comments on social media from our viewers who are watching this all unfold, and it's interesting to see how different they are reacting to this. One asked, he's standing right in front of this TV screen. Is he trying to coach her? Another said, wow, he's heartless. He's only thinking about himself because he's forcing her to testify when she's clearly not in a good situation. That seems very prejudicial when he's really just trying to get her to testify. Do you think he should be moving for a mistrial at this point?
You know, I don't think he knows how to move for a mistrial, to be honest with you. This person, you know, he's a deranged person, but ironically, he kind of comes off as magnanimous at this point, in my opinion. Magnanimous in the way he's treating her and telling her, you know, don't be rude to Mr. So and so forth. This is the first time in the trial where he's actually coming off somewhat nice, in my opinion, to the jury. But he's a deranged person. Having an attorney would have I can't believe he had this gift of this person willing to testify, this victim, saying that he wasn't the person who did this, right? And he is squandering it by not having a counsel. Even attorneys don't represent themselves. So it's not about knowledge, it's about just common sense. Don't represent yourself. But he's squandering this gift that he has, which is this witness. You want a jury to go back into the box with one overwhelming feeling, and that's doubt. And if they can hear her say that he was not the person who attacked me, and look at this picture. If he can find a way to introduce that, I think that's his get out of jail free card, but he doesn't know how to do it. Should he move for a mistrial? I don't think he knows how to move for a mistrial. And to be honest with you, what would be better for him than moving for a mistrial is moving for an exception to the hearsay rule where, you know, the witness is not available. So let's look at prior testimony under oath of her testimony. He can introduce that. And if he introduces that, I don't see how you don't have reasonable doubt that he committed the crimes that he's accused of. I just don't see how you could do it. Juries could get it wrong, but not like that. Not like the victim itself saying he was not the perpetrator, and still a jury convicts.
Yeah, so let's take a look at that statement.